Please be seated. Okay, our next case is Crum Insurance versus Department of Financial Services. Are both sides ready? You may proceed.
Good morning. It may please the court. I am Paul Amundsen, Lewis, Longman, and Walker. I'm here on behalf of Crum Insurance. This case arose from the dismissal of a petition for an administrative hearing.
Okay, would you like to reserve any time for rebuttal?
I would. 6 minutes for rebuttal.
Okay.
Thank you, Judge. On the basis of standing, and the basis for the dismissal was that the petition was filed by a service company engaged by Crum Insurance, Cost Containment Solutions. It is Crum Insurance Company's position and my position that it should not have proceeded to that point because the provider of medical services, which is Tampa General, did not timely invoke its right to contest the review of the charges. And we have a statutory scheme in 440.13.07, 13.7a. And I believe the court is familiar with the workers' compensation law. It governs these kinds of disputes. And it says that once the provider, that is Tampa General in this case, receives a EOBR, which is the acronym for the review of the charges, the provider has 30 days within which to contest that. And if they do not, they have waived their right to contest that. In our case, Cost Containment Solutions provided the EOBR to Tampa General September 25th, 2009. Tampa General did not do anything with it.
Counsel, let's go back to I guess it's the August 11, 2009 explanation of review. While that informed Tampa General that the explanation constituted a notice of disallowance, it provided that, and I read this quote, reconsideration requests must be received within 30 days.
Yes.
And doesn't that seem to imply that the disallowance is not final and there's to be more consideration by appellant?
And you're referring to the one by Broadspire, which is at page 85 or page 210 of the record. And I'll add the record is replete with duplication. But that
I'll have to admit, plowing through this was a confusing exercise.
yeah, and it was too confusing because there really aren't that many documents in this record. There's just too much duplication. But the August 11th explanation of review was prepared by Broadspire, and it does say those words. And it was followed, Judge, by a check for in the neighborhood of $289,000. And then that was followed by what you will find on page 221, 247, and 118, on page 241 of the record and elsewhere, but the most legible version of it I find is on page 241, which is the cost containment solution review analysis. And it comes up with the same number that the check was written for, which is $289,780 and change. And yes, and so to answer your question, yeah, the Broadspire EOBR, it says those words, and
But is that a normal part of the process that's intended? It seems to me the way the statute's read, you receive the notice of disallowance and you have 30 days to basically appeal.
That's right, Judge.
But this reconsideration request has been added, which it seems to me would just add confusion if it's not provided for in the statute.
And I don't think it is provided for in the statute. And I don't think whatever it said would change what the statute requires. And in any event,
doesn't that run the risk of Tampa General here saying, well, let me add some more information in this reconsideration request before we go the next step? And it seems to me that's an error that's been caused by the language in the EOBR?
EOBR.
Counsel, in regards to the EOBR, the two carrier responses to Tampa General Hospital's petition were filed with the department, each of which stated that a different explanation of the bill review, that is the EOBR, applied. The department then issued a notice of deficiency, and there was no timely response to that. Based on these facts, why didn't you not waive your right to argue that the petition was untimely?
The notice of deficiency came in along about April of the following year. That was preceded by a check for in the neighborhood of $13,000 to Tampa General. That could not have caused a waiver, Judge, and I'll explain why. If you go to page 118 of the record, you will see Cost Containment Solutions, a second EOBR, showing recommended allowance of $13,140. And if you look, and this is important, I would invite the court to take a good look at this document because it shows that the provider charges, all of the provider charges on this document total $13,140. And they were paid $13,140. And so the notice of deficiency, it says, and I'm looking at page 123 of the record, please provide a copy of the EOBR pertaining to this check, referring to the $13,140. And it is contended by my colleagues that this caused a waiver. Well, you can only waive. They paid the whole, pardon me, Judge.
But the notice from OMS also said if the required a curative document to be served upon Tampa General within that curative documentation to be provided to the department within 10 days. And it stated expressly, if the department doesn't receive the curative documentation and proof of service within 10 days, the department deems this constitutes a waiver of all objections to the petition. That's the waiver, it seems to me.
Except,
again, counsel, in view of these facts, why did you not waive your right to argue that the petition was untimely?
Because the $13,140 was a supplemental payment of the entire amount claimed. The deficiency notice and that procedure requires an explanation of adjustments or disallowances. There were no adjustments. There were no disallowances. They were paid the entire $13,140. There could be no explanation for an adjustment or a disallowance because there weren't any. And this happened, and I will point out, this happened months after the initial EBOR. So the payment of an amount in full for those 3 pharmaceutical items months later, it would not make sense for that to revive the right to contest the whole thing that was waived months ago.
You're down to about 5.5 minutes.
Okay. I will reserve the rest of my time for rebuttal.
Counsel, before you sit down, I have one other question for you.
Yes, Judge.
How were cost containment solutions substantial interests affected so that they could properly file a petition for administrative hearing in these proceedings?
Yes. Okay. Standing. I think they have standing. There's some administrative law precedents, not by this court, suggesting that only carriers and providers have standing. The statutes, and it's going to take a little bit of an explanation here, this statute does not contain any language that limits who can be a petitioner. Other statutes do. 163 does as to comp plans. 408 does as to certificate of need challenges. And there's others. There's no limitation here. And in fact, if you look at the statute or the rules, both of them make reference to providing notice and service to the carrier and other interested parties, suggesting there are other interested parties other than the carrier. And I would suggest also that Cost Containment Solutions, which was the petitioner here, is such an interested party. And in fact, they received notices routinely from the department. And in fact, they received a notice that said, you have a right to an administrative hearing, and if you don't file for an administrative hearing in 21 days, you waive that. So they did. So everything points to Cost Containment Solutions having standing. I think it was erroneous. And by the way, you could make out a case, Judge Lewis, that it would be foolhardy for this matter to proceed forward without Cost Containment Solutions because they did the analysis. Why wouldn't they have standing? I submit that they do. I do not think that this matter should have proceeded to that point because the train left the station when Tampa General failed to object to an EVOR that they received September 25th. They did nothing with it. It was coded correctly. It used the department's approved codes.
Yeah, but following up on Judge Van Ortwerth's question, since you reopened that, they filed a motion for reconsideration, which seems to indicate that they were confused and they felt that they had a right of reconsideration based on the initial one sent out by the carrier itself. So why should we require a waiver on their part when they were just initiating a process that it seemed that your clients, allowed them to follow? Understand my question?
I think your question goes to whether discussions, negotiations, and communications can toll that time.
No, it doesn't even go to tolling, because tolling, but it basically set out reconsideration. And that to me seems that this is really not a final, following up on Judge Van Ortwerth, that this is not our final say. We're still willing to play, talk and play the game for a while.
Yeah.
So,
I didn't see it that way, and I think if were there any doubts, the EOBR sent by Cost Containment Solutions, which followed the Broadspire EVOR, it's a different document. It's coded correctly. It adds up to what they were paid. That is the document that starts the 30-day clock, and there should be no ambiguity about that.
Okay.
Counsel, as a follow-up, as regards to the tolling point, is tolling ever allowed under Section 440.13?
I'm sorry, Judge, I didn't hear.
Is tolling ever allowed under Section 440.13?
I'm sorry, is what allowed?
Tolling.
Coding?
Tolling. T-O-L-L-I-N-G.
Oh, yeah, I'm sorry. Yeah, tolling, I do not believe so. I don't think it can be tolled. And there's an administrative law final order entered by the Department or the Agency for Healthcare Administration when that agency was administering this program. That says exactly that.
Follow-up. Is tolling and waiver two separate concepts, though?
Are tolling and waiver two separate concepts? I think so.
Okay.
Yes.
Thank you. Okay, you're down to a minute. What I'm going to do is give you 2 additional minutes, and I'm going to add 2 minutes to the other side. Keep it all fair. You got 2 more. You're going to have 2 minutes and 46 seconds. They're going to have 17 minutes.
Thank you, Judge.
Good morning. May it please the court, I'm Mary McCulley. I'm counsel for the Department of Financial Services. I'm accompanied by Mr. Joseph May, counsel for Tampa General Hospital. From the inquiries of the court to Mr. Amundsen, it would appear that I might be better prepared to respond to your questions, though I would normally give Tampa General the courtesy of going first, given that it's their substantial interests that are at stake in this appeal. If I'm incorrect, please let me know. Otherwise, I'd like to go forward and give you the department's side to the questions that you were posing.
Okay, are you going to be splitting time between the
I
two?
will save some time for Mr. May to make a presentation.
Okay.
Questions first relating to the 3 EOBRs. EOBR stands for Explanation of Bill Review. I will fall into just using the acronym out of habit and because it's such a common term in the industry for healthcare providers and the insurance companies that are responsible for providing reimbursement.
Okay, let me ask you a question.
Yes, sir.
Specifically on that. If the September 12th EOBR had not been sent to create confusion, and I understand the problem about creating confusion, would the September 25th, I guess that it was, the second EOBR sent out, the one that was sent out by CSS,
Yes, sir.
would that have started the time clock?
It's the department's position that no, it did not.
Why not?
First of all, that was issued not by the third-party administrator that is responsible for paying on this claim, Broadspire Services. Broadspire issued the first EOBR, and Broadspire said, this is your notice of disallowance. That language is specifically required by the department's billing rule to be included on an explanation of bill review. That's Rule 69L-7.602, paren 5. And that rule also sets forth the explanation codes that you're supposed to use when you're advising the healthcare provider as to your adjudication decisions on a line item basis as to each line item that appears on the hospital's bill. This is also important for the department's own reporting requirements. The department collects data from these electronic reported EOBRs. On that first EOBR, there are a number of line items where in the allowance column it says 0.
Okay, I want to ignore the first one.
Okay.
Give me a hypothetical. Let's say the first one didn't exist. And I understand your position that the EOBR had to be sent by Broadspire and not CSS. Putting those two things aside, would the September 25th EOBR sent out by CSS, would that have been sufficient to start the time clock?
No, again, I believe not, because it does not specifically advise the healthcare provider that this is your notice of disallowance or adjustment of charges in accordance with Rule 69L-7.602.
Okay, that was my question. Thank you.
And I think a bill review company, I'm not sure that the EOBR must be issued by the third-party administrator or the employer carrier. I do think it probably can be one issued by the bill review company, could probably initiate the 30-day time period, but only if it's a proper EOBR.
What about the other EOBRs, counsel? How are they insufficient?
The first one was not really insufficient. It gave the notice that this is your disallowance or
That's the
adjustment of
August
charges.
11
Yes, sir.
EOBR.
And it,
What about the reconsideration language in there?
the reconsideration, I find this one very interesting because appellant claims that this last EOBR did nothing more than provide a payment in full for 3 specific items, namely a pharmacy charge of $8,800, a pharmacy for radiation charge of $39, and a treatment room charge of $4,221. Now, while it's giving reimbursement, the code given on that partial EOBR says payment disallowed. You're giving payment, but you're telling the hospital that this payment is disallowed. How is that an explanation of why these 3 additional charges are being reimbursed.
And that's the 13,000 some odd, that was part of the initial Tampa General bill, wasn't it?
Actually, I have gone back, and the court may as well, and I don't see on the hospital's bill where there is a pharmacy charge of $8,800, or a pharmacy for radiation charge of $39, or a treatment room charge of $4,221. There's actually, I believe, 11 units of treatment room charges. And there is a number of pharmacy charges, and there's some pharmacy for radiation charge, but I don't see those specific charges anywhere on the line item, the bill, much less going through the itemized statement of charges. Now, they might be somewhere in that itemized statement because it's about 10 pages long. This was a 3-week hospitalization. The charges were over $600,000. Now, I would, if I were Frank Winston Crum, not rely on an obviously unsophisticated bill review company to be going and asking for administrative hearing regarding such substantial interests.
Counsel, make sure I understand you. Are you indicating that the August EOBR was sufficient to meet the 30-day deadline?
Yes, sir.
But the September EOBRs were not sufficient to meet the EO?
That is exactly what my position is. And the reason why, however, the problem with the first EOBR is it tells the hospital that you're going to be paid $409, actually $405. I think I represented $409 in my brief. For the review, the recommendation was $405. Well, interestingly, when the hospital did finally petition the department to say, hey, will you please resolve this reimbursement dispute because we're getting mixed messages, they only calculated the reimbursement that they thought they were entitled to at somewhere around $385,000.
So there was no reason for them to challenge the first one.
Exactly. They're expecting more money than even that they had calculated, or assuming they had calculated. So how can that be said to have initiated the 30-day time period? Once they got the check, that was only in $289,000. Perhaps they should have petitioned us right then. But when or how? They don't have an EOBR that explains why this $289,000 payment is issued. Then they get the one from Cost Containment Solutions, but that Cost Containment Solutions EOBR, even though it uses the same codes that were used in the first one, the compliant one, it comes up with this totally different reimbursement amount, somehow supporting what was issued, but that payment had been issued by Broadspire. All of a sudden, we're getting this EOBR from Cost Containment Solutions.
Okay, the Cost Containment Solution one did not say it was an EOBR.
Correct.
And that's problematic to me. But if it had said that, and there were the deficient coding in there, how would Tampa General at that point know whether to start the process or not?
Because
Understand my question? The question of having small deficiencies, and I'm not saying it's small, but deficiencies, if it purports to be an EOBR, doesn't the hospital have the obligation at that point to begin the process?
I think possibly yes. However, these are not just minor technical deficiencies. I would submit to you that these are such major deficiencies that none of them would invoke trigger the 30-day time period for petitioning the department. This is, and also you were mentioning the waiver versus tolling. It gives me great concern from my experience working for the department when these EOBRs say, hey, you got problems, call me, which is exactly what the hospital did. When it got the second EOBR, Cost Containment Solutions says if you've got questions, contact us.
And I should
is tolling appropriate under Section 440.13?
It has not been determined to apply. There used to be a rule when the Agency for Healthcare Administration administered the statute. They had an administrative rule that specifically provided tolling of the period where the parties were engaged in negotiations.
And I'm getting confused, so help me here. Is there in the statute of rules specifically a requirement that the EOBR state that it was an EOBR?
Yes, there is.
Okay.
Under 69L-7.602 paren 5, and that is a very lengthy paren
I read
5.
that, I thought I read that somewhere, and I just,
Yes, sir.
okay.
It must advise the healthcare provider that this is your EOBR. This is your, it doesn't have to say EOBR. This is your notice of allowance or disallowance or adjustment of charges, which the second EOBR did not do in this case. And again, also the second EOBR did nothing but create more confusion. So I would submit to you, even if it said this is your notice of disallowance or adjustment, because it created such confusion as to the coding and what was actually paid, and it contradicted what they had been advised with the first EOBR, which was absolutely compliant and checked out, that it shouldn't have started, even if it said this is your notice of disallowance. I would say that is such a non-compliant EOBR that you could not say that it started a 30-day time period. That's my personal opinion from my review of these EOBRs.
And the language reconsideration request must be in writing and received within 30 days. It's in the August EOBR. Is that part of the normal practice?
I see that a lot. I believe it's misleading. It brings you down a path saying, oh, well, we'll work with you, just like you were saying, Judge Wolf. Exactly. And you see that language even when you do see the language that says this is your notice of disallowance or adjustment, but that they will also sometimes say, but contact us first, like you're being baited and switched. Not that I would accuse that is what occurred here, but...
Well, in fact, you might want to encourage some dialogue to work it out so that you don't have everything in a formal proceeding.
Absolutely. And my understanding from members of the industry is when the Agency for Healthcare Administration had that rule that provided for reconsideration, but a lot of these were actually worked out before they were brought to the department.
And that was my reason for my question about waiver versus tolling. Because clearly the agency, and you correct me if I'm wrong, is taking the position you can't toll the time.
Yes, we have. Both on the...
That language about reconsideration, to me, arguably, is a waiver versus tolling. Has the agency taken a position on whether that language could constitute a waiver?
In the Monroe case that appellate relies on, we did find, or the agency did find, that the healthcare provider had waived its right to petition the department to resolve the reimbursement dispute because it did not do so within 30 days of receiving an EOBR. The problem was those...
I'm talking about waiver on the other side.
Waiver for the healthcare, for the carrier, absolutely, and that has been affirmed by this court, that a carrier's failure to respond or to provide the supporting documentation that it's required to provide pursuant to 440.137 paren B is an absolute waiver of your right to request for an administrative hearing, and I would say as well as appeal of a final agency final order. I'll rely on my brief as far as the waiver is concerned, but and also for the standing, but you did have some specific questions about standing, and I would submit to you that neither Cost Containment Solutions has standing, and that the fact that they are a bill review company, admittedly, and that has been upheld by this court as well, but neither do they have standing to ask for an administrative hearing on behalf of the appellant, which is what their second request for administrative hearing represented. In response to the department's order to show cause, they said, okay, you're right, we're not a carrier, we don't have standing, but we're here on behalf of the appellant, who we submit does have standing. The civil rules of procedure do allow for a party to represent other parties' interests. I liken it to a loan processing service agency. Judge Van Nortwick, I think maybe our homeowners in this district are not quite as distressed as they are in cases in other areas like in the 4th District.
Okay, I wanted to let you know you're down to about 3 minutes. I didn't know whether you wanted to give your...
Yes, I will.
...your cohort some time.
I would like to finish then that under the teachings of this court in Brookwood versus ACCA, the department was required to give the cost containment solutions another bite at the apple to petition for an administrative hearing. We did that. I would submit that we were not required to give them a third or a fourth chance, and even had Frank Winston Crum properly petitioned for the department to grant them administrative hearing, this record supports the determination as to the reimbursement amount that was given, and the final order should be upheld.
May it please the court. My name is Joseph May. I'm one of the attorneys with the law firm based in Jordan. I'm here on behalf of the appellee, Tampa General Hospital. This particular case is, first, you need to keep in mind the overriding philosophical approach that the workers' comp section is intended to achieve, and it is intended to achieve a self-executing, timely, and efficient way of processing providers' claims, claims in general, but it includes providers' claims, and it does so in a scheme that is set up to be self-executing, and it is done in a way so that situations like this, where a provider has a dispute on a reimbursement claim, it has a vehicle whereby it can seek a remedy. In this case, we would submit that the agency or the Office of Medical Services was correct in its assessment of this case, and the way they processed the claim was correct, and that when the response by the carrier was deemed insufficient, the ruling on behalf of the hospital was correct. In this case, the initial document that the hospital received indicated that the hospital would in fact be paid $405,000, and at the time that they received that, there was absolutely no reason for them to take any further action. When they did finally receive a payment on this claim, it was more than 30 days after that document was received, and that was when they became aware of the deficiency and the problem. So the notice issue, if there is a notice problem in this case, it was created by Crum, CCR, and Broadspire. Broadspire, particularly, when they issued that first notice, the indication was that there was going to be a $400,000 payment, so there was no reason for the hospital to take any further action. When it received the $289,000 payment, based on a strict interpretation of, I'm sorry, my time's expired.
I'm going to give you about 30 seconds to.
Okay. If the hospital had been able to take any action, it would have been before they ever even received payment. So the 30-day period for them to respond was essentially over by the time they got the payment on the thing. So you can't look at that initial explanation of the OBR or EOB as being sufficient in and of itself, and especially under the circumstances here. So any bright line rule that might have existed would not apply in this case. The fault would have inured to Crum.
Okay, thank you very much, Counsel.
The EBOR that was issued by Cost Containment Solutions, it has, to my knowledge, has never been stated by the department through this record or in any brief that it wasn't an EOBR. And I would suggest that Tampa General, upon receipt of that document, knew or should have known that it had 30 days to object to it, or they waived that right. Now, as to the claimed waiver by the carrier, that is suggested to result from a payment of $13,000 some. Months later, which was a payment in full for 3 pharmaceutically related items. And I would suggest you look at that document that was sent with that check. You will see that, as counsel pointed out, it was coded 60, which means disallowed. It was coded wrong, because if you go across the page, the provider's charge and the suggested allowance are the same. So, yes, it was coded wrong. Is that a waiver? Should my client or CSS have provided something that was impossible to provide, and that is an explanation for a disallowance or an adjustment when there was no disallowance or adjustment? I would suggest that can't possibly form the basis of a waiver, because they were asked to produce something that couldn't exist. Now, and this brings the point to the policy behind not considering that a waiver, because should a reconsideration and a voluntary payment in full of an amount to a provider months later, should that be allowed to revive a long past deadline to contest things that
I'm more
have-
concerned, counsel, with the idea that the deadline had actually run. Because of, it seems to me, and I directed my questions to counsel for the department about the necessity for the hospital or whoever the provider is to be on notice that there is a document that effectively has ended the process and requires the appeal to go on. And I'm real concerned that there was no such document. The first one said it was an explanation of benefits, had reconsideration in there. And then according to the department, the second one did not have sufficient language to alert the other side, to alert Tampa General, that this was an explanation of
Yes,
benefits.
and that's a contention I heard for the first time today. And I've looked in the rule. I'm not saying it's not there. That particular provision that was cited is about 3 pages long, and I've just been looking through it. I can't find it.
Counsel, for the sake of argument, you prevailed in this appeal. What relief are you seeking from this court?
A finding, a reversal with instructions that Tampa General waived its right to contest the EBOR, and this case is effectively over with. Alternatively, a reversal finding and remand, finding that, as I explained, and I think the case law lines up behind me and the statute and rules line up behind me, that CSS should be allowed to file a petition for a hearing. And the basis for the final order that was entered, the only basis for the final order that was entered, was CSS's standing.
Okay. Your time is running, counsel. Thank you very much.
Thank you.
We have one last case on the docket, Scott Eaton versus City of Winter Haven. Counsel, in that case, can take your time getting up here.